and welcome to today's seminar brought to you by the Grace Church Foundation Board. I'm Gina Grammaroso. I'm a 36-year member of Grace Church, getting ever so close to that Harvest Home 50-year mark. I'm joined today by Scott Oates, who is the chair and president of our foundation board. He's on Zoom. And then we have some other foundation board members here. John Abbey, you want to wave? Everybody knows John. And Scott Skoogland. And I'm not sure if, and Ron Blob, sorry, Ron. And I'm not sure if Tim Ford got on the call, but I think he was going to try to join us as well. We have about 25 or so people on Zoom or here in the room, and we're just delighted that you joined us. The Grace Church Foundation was established in 1992 out of a need to think about the church's future and to endow and support the mission and the ministry of Grace Church. A sampling of the work that the gifts of the foundation have supported over the years. Recently, we did the renovation project, and that was thanks to a bequest by Glenna Holloway. The Lacey Garden, which is so beautiful, and that was a gift from Jenny Lacey. Faith Build is also something that the foundation supports. That is a mission where we help build homes with Habitat for Humanity for families in need. And then we do a lot of educational and training support, not only for the clergy and staff of the church, but also for members. And then we also support a scholarship at North Central College. Side by Side is our youth mission, and we do a lot of support with them as well. And all of this is because of the very beautiful generosity of our members. And so we're so grateful for that. I'm going to turn it over. I'm going to introduce you to our speaker today, Ted Cusack. Ted is a graduate of the University of Wisconsin at Whitewater. He has a business degree, and then he has a law degree from John Marshall Law School. He's very involved in his own parish and is also on the Plan Giving Advisory Council at the Food Bank where I work, and that's how I know Ted. He's a very frequent speaker on this topic and just phenomenal. And we're just delighted to have you today, Ted. Thank you so much.
Thank you. Okay, so we're going to hope that technology is our friend today. I'm just going to say that it's okay to be recorded here. So I've been told that in an environment like this, where I'm the speaker on the front, I can do without the mask. Is that kind of where we're at because we're far enough away from each other?
Yeah, I think so.
So I'm the only one that can breathe in here now, sorry. So I like to keep this light. I'd like, if you would, keep questions until the end. That way we can get through all the material. I hope to be done with the material by about 1 o'clock-ish. And if you have questions, I'll stick around as long as you'd like me to answer any questions that you've got. And I tell a couple of corny jokes along the way, so it's okay to laugh here and there. And so now the first piece of technology that we're going to see how it works is my remote from my phone. So here we go. It says play. I see my slide, and there we go. So my first question is, do you now, or have you in the past, or do you just know someone that's had a small child, right? And we all have, right? So what we know about that is that somewhere along the line, parents are going to leave their children behind with someone besides grandma and grandpa. By the way, I became a COVID grandpa. I have a 15-month-old grandson right now. And my grandson is now, for the first time, being left behind with someone other than grandma and grandpa. But the first time a parent does this, typically they'll leave behind a detailed set of instructions, and then maybe they go out to dinner. They get to the restaurant. However, what do you think is the first thing that most parents would do? Call home, right? Because you want to check in, and you might want to add to or change those instructions. And that's the great thing about being alive, is that we can always change our instructions. So the question I put before you today is, what kind of instructions will you want to leave behind when you're going to go away forever, right? So you want to leave some good ones, because where we're going to talk about going to this afternoon, as far as I know, you can't call home. Oh, someone did understand that was my first joke. It's kind of a long delivery. I'm telling you, they're not going to get a whole lot better, but at any rate, thank you for that little chuckle. So good instructions have to do a few basic things. Control your property. That's my main job, helping people control what they have, giving not only what they want to whom they want, but more importantly, when and the way. So if you want to leave money behind for the college education of a child or a grandchild, you better have some pretty good instructions, right? Because they may have some other ideas of what should happen with that money. And then most people want to minimize costs, minimizing probate costs, legal fees, and taxes. We're going to cover all those things today. There's 3 evils in estate planning: living probate, and death taxes. I'll address each one of them. But I'm not going to bore you with legal code sections. There are many areas of the law that go into estate planning. But rather than do that, I'm going to tell you a story. Today's story is about Bob and Pam. They're married, and they have a $2 million estate. And you might immediately say, Ted, is this going to apply to me? I don't have exactly 2 million. I've got less, or I've got more. No matter what size your estate is today, will help you to estimate your probate costs and your taxes if you've got them. And then you may be single, widowed, or divorced. We're going to cover that situation as well. But Bob and Pam will kind of be the base that we work off of. They have some pretty common goals. The circulating arrow on the top means they want to control everything between the two of them. When the last one passes away, then they want to give half to Susan. She's the perfect child in the family. She always makes good choices. John's on the other side of the spectrum. By the way, how many of you have a Susan type in your family? How many of you are the Susan type in your family, right? That's why you're here, right? Now, John's never coming to this program, if you know what I mean. He took a wrong turn back in the 1970s, and he hasn't found his way back yet. But my point is, our kids are beneficiaries. Whoever we're going to leave our assets to, that are all very different individuals. And it's important that a lawyer understands those differences if they're going to help you custom craft something that fits those individual circumstances. And we'll talk a little bit about how boilerplate and short-term meetings, things like that, don't really lead in that direction. You have to have some time to share stories about your family with the lawyer who's going to help you. And if it takes time to share those stories, do you suppose you want to pay that lawyer by the hour? Probably not. If you're anything like me, when you're paying by the hour, things tend to rush. And rushing through the estate planning process doesn't necessarily lead to the best plan. So we're going to look at different ways of owning assets. The first would be joint tenancy as a way to actually transfer assets when you die. And the way that happens is during lifetime, husband and wife, say, own a house in joint tenancy with right of survivorship. The first one passes. 1 second later, the survivor owns it immediately. And if you understand that about joint tenancy, that's really all you need to know for today. A simple will is a set of instructions that says where your assets go when you die. But what has to happen to you before a will can take effect? You have to first what?
You're right.
You have to write it. And then what happens once you've written it? What has to happen before it actually takes effect? You have to
sign it.
Sign it. You're getting there. One more thing before it actually works, you have to die. All right. So, and by the way, these aren't trick questions. If I say something like that, I'm meant to solicit easy answers like what you gave me. That's perfect. So the point is, a will can't help you do anything while you're living. It's a worthless piece of paper until you die. If you get sick, for instance, a will can't say who controls your assets or your property. And we'll get into that in a little bit. Let's say Bob gets sick. He's lying in a coma, not expected to die. They expect him to wake up. They're just not sure when that's going to happen. And after several weeks or months, perhaps, Pam decides, when Bob gets out of the hospital and rehab, we're not going to be able to live in that house anymore. Our bedroom's on the 2nd floor, and we're going to need to move somewhere else. She wants to sell that house, but the house was in joint tenancy with her and her husband, or the house was in Bob's name individually. Maybe he owned it before they were married. And now Pam wants to sell that house. Can she sell that house while Bob lies in the hospital or is in the rehab center? No, she needs to become his guardian. So neither joint tenancy, which is both names on the deed, or simple will, which would be using it to transfer at death, will work. So we're stuck with the first evil of estate planning, which I call living probate. What is it? It's a lawsuit designed to protect the person who's disabled. So we're talking about protecting Bob from basically Pam. Now, they may have not thought that that was something that they needed to protect against, but in this case, this is what the court is involved in doing. So the first thing that Pam does, she hires a lawyer to go to court. And what does she want to do? She wants to sell the house, right? So she's got a contract and she likes the sales price, but who do you suppose decides if the sales price is enough to protect Bob's interest in that house? It's going to be the court. So let's say the court approves. Our market's up right now. The court should approve, right? So Pam gets to sell the house. She's got some money. Can she simply go and invest it wherever she'd like? You probably know from the way I'm asking the question, it's going to be subject to court approval, as well as spending. So these are all done on an accounting to a court in a guardianship, which is another name for this proceeding. That'll go on usually until Bob passes away. Now, when someone passes away, remember the two processes operate a little differently, right? So with joint tenancy, the house would immediately be Bob's. But under the will, say Bob, again, owned that house in his own name, the will isn't going to pass that home to Pam until the will goes through probate. So here's the joint tenancy example, right? Immediately goes to Pam. And here's the will example needing to go through probate. So let's talk a little bit about probate.
Hey, Ted,
Yes.
I'm sorry, it's Scott.
Yes, Scott.
I know some people may be taking notes. Could you just slow down just a little bit?
That was the one tip my wife gave me as I left the house this morning. So thank you so much for
I'm
telling
sorry,
me
I'm
that.
sure you're trying to get everything
I've
in.
been doing programs for a while, and I sometimes go a little bit on autopilot. So yeah, just put the brakes on me again, Scott, if you or Gina, yeah, anybody in the room here. I'm going too fast, slow me down. So death probate is a legal process of transferring assets to the heirs. And kind of like when we started with living probate, it sounds okay, laudable, until you actually get into it. The primary purpose of death probate is to pay off creditors. When someone dies with a will, the will goes to the probate court, and then a legal notice gets filed in the paper and then online. You've all seen legal notices in the paper before, right? You don't read them, but if you did, some of them would be probate notices that basically say Bob is dead, and if you think he owes you money, now's the time to come get it. Does anyone know how long that ad has to run and how long the claims period is? 6 months. So after that, then the attorney can march back into the court with an executor. That's the person, the boots on the ground that you name to help manage things with the lawyer to get a final accounting and distribution of the assets, which is the changing of the title of the assets into the names of live beneficiaries, right? We had a house that was stuck in Bob's name. In our example today, what we're trying to do is get it transferred over into Pam's name, right? Now, this doesn't happen very often, right? Because most of the time, married couples own their house in joint tenancy. So this can happen, again, with later on in life marriages or second marriages where people came in with assets that they owned from earlier. What else happens in probate? You're going to resolve any disputes. Uncle Bob said he was going to leave me some money. If I didn't get it, then maybe I'll file a claim against the estate. All the claims need to be dealt with. Inventory and appraise all the assets, and then finally make the distribution to the beneficiaries. But as you can imagine, there's a number of expenses involved. Of all the fees that I have listed here, which one do you suppose winds up being the largest by far? Attorney's fees, right? All of a sudden I got a room full of attorneys, right? Y'all figured that out. So, the lawyers in Illinois charge what's called reasonable fees. That's not one of my jokes, but it's actually kind of funny, right? What does that mean? Well, it basically means whatever the probate judge says is fair. Now, I represented an attorney in 2016 that does just probate work. Now, he told me he averages about 5%. When we look at major brokerage firms that will do an analysis of your estate while you're alive and then when you die and what's left to your family, most of the major brokerage firms will use 4%. So think for a moment of the value of your estate, the assets that would be stuck moving through probate when you pass away, and apply a 5% factor to that, or a 4%. I mean, you can apply whatever number you want. In Illinois, we're only guessing because lawyers in Illinois are going to charge by the hour, right? So even though this lawyer told me he gets about 5, that's just what he told me was sort of his average. You can't substantiate that in Illinois, but there are states where that's the case. If you happen to own real estate in a state that has a percentage jurisdiction, you'll have another probate. Even though you might live here in Illinois, you might have a separate probate in that state, and that lawyer would be paid according to that state's laws. Perhaps a percentage would be applicable there. And there you see sort of that 4% is kind of the average that we're going to see among many of the major brokerage firms. But 4% or 5% or 2% of what? Well, if you had a house worth $300,000 and you had a big mortgage on it, and the net was only $1,000 of equity, you suppose the lawyers that charge a percentage calculate that percentage based on the gross or the net? The gross. And actually that makes a little bit of sense when you think about it, because if you had, say, $10 million worth of assets and $9,999,000 worth of debt, you'd still have only $1,000 worth of equity, but that would certainly be more complicated to disperse, right, than this situation. So working on the gross actually does make a little bit of sense. So in this case, we'd have $12,000. And so the family would have probably walked away from this house before they would, this hypothetical, right? No one's actually going to pay $12,000 to gain a house with $1,000 worth of equity. Probate's also public. How many of you would like to share a list of your assets? I'd like to put them on. This is going to be recorded forever so everyone can look at it. And we want to get your assets up here on a screen for everyone to see. Anybody want to volunteer for that? Yeah, not so much, right? Yet probate is completely public. If you want to know the financial details of anyone with a probate estate, the only thing you need to know is the county they lived in. And you can go to the county courthouse, receive the file. You don't have to be a lawyer to do this. And you'll find an inventory. That's that list of assets. You look a little farther, you'll get the disbursements. These are the bills that were paid. And then finally, a copy of the will. So now you know who has those assets. If we didn't really want them to be shared with 20 people on a Zoom and live here, do we really want the public to be able to get access to that? Currently, you cannot get that access online. You have to actually go to the court. Some jurisdictions, however, make that available just with a mouse click. We talked about a couple of these now, multiple probates, different states if you own real estate in different places. Death taxes. Now, your tendency perhaps would be at this point to check out once I start to tell you when taxes are payable, because under the current law, most people don't pay death taxes. But I'm going to explain to you what they are because they're always changing, and I guarantee you they will change over the course of the next several years. They've changed no less than 8 or 9 times over the course of my career. So let's look at death taxes. There's 2 kinds. There's Illinois, and then there's federal. So Illinois, for all intents and purposes, doesn't tax an estate until you're over $4 million. But once you are, then they tax it, and you've got rates there, which is between 9 and 16. The actual, the 16 is going to go up the first of next year to 21% in Illinois. So you can see, many clients wouldn't have 4 million. Those who would, we need to look at taxes as well. Now, then there's federal taxes. Federal taxes, the rate is much higher, 40%, but the limit before you pay the taxes is also much higher, $11.7 million. I just got an article today. When they get together on Capitol Hill, what's the group that's kind of the most powerful that starts to admit legislation? I don't remember the name of it off the top of my head. But anyway, this was a release. Basically, the latest proposal would be a $5 million exemption as of January 1. That was going to happen in 2026 under the old law. The old law expires. So right now you can leave $11.7 million with no tax. But in 2026, under the current law, that was going to expire and roll back to the 2010 limit of 5 million plus an index. So it would probably be somewhere around maybe 5.5 million in 2026. The proposal is to get that passed to take effect January 1 of this year. There's also what's known as an unlimited marital deduction trap. So there's a law on the books that's been around, and this isn't likely to change, which says all money to a spouse is tax-free. So when you die, you leave everything to your spouse. You don't have to worry about taxes. So what could be possibly wrong with that? Why would I call this a trap? Let's say that Howard Hughes was married on the date of his death, and on the date of his death, he left everything to Mrs. Hughes, $5 billion, let's say. What would the tax be under this law? 0, right? Now, Mrs. Hughes probably not dying the next day, right? She lives another 4 or 5 or 6 years, and maybe that estate even goes up, right? And then she passes away. Are the kids going to be able to go back and claim Mr. Hughes's exemption? No, and let me explain to you why this is. The exemption is like a coupon. Does anybody in the room use coupons besides me once in a while? Okay, so what do you look at on your coupon before you use it?
Expiration date.
Right, and so this coupon expires when you do. Not you specifically. All of us have this coupon, this ability to leave money behind tax-free, but it only lasts for 9 months. And after that, it expires. So if Mrs. Hughes lived 2 years, 3 years, 4 years, or 5 years, the kids, when she dies, can't go back and grab his coupon. One of the things I'm going to show you today is how to use your coupon and still let your spouse have access, right? Because one of the things to do would be, hey, you die, we'll leave $4 million to your kids. Well, that might leave your spouse high and dry. So we don't want to do that, but I'm going to show you how to leave the access to your spouse, gain your coupon, and then so when the second one dies, you'll have a second coupon left. So we'll get to that in just a minute. So on the screen now are the exemptions, and we just put a great big question mark down there by 2022. We actually adjusted that today because I literally just saw that this morning. And the sunset provision is the old law that set it back at the end of 2025. So you can see how it's changed. All right, this is not something that's going to be constant. It kind of blows like the wind. And it's interesting because some administrations have signed into law taxes that they didn't actually agree to because they just couldn't get their wishes in place. The current administration wish, as I understand it, is to bring it down to $3.5 million. But there seems to be agreement perhaps at 5 million. So we'll see what happens. This is not unusual, by the way. Under President Obama's administration, he also wanted it to be, I think, $3.5 million, and he signed the law at 5 million that extended the Bush tax cuts. So that's the law that we're living with right now. So if you're below 4 million, we're back on the state tax now. Do you have federal tax? No, because that's way under 11.7. If you're under 4, we know that you don't have a state tax, right? A state, not a state, a state tax. But do you have probate? Yeah, you're still stuck with living probate because that's a guardianship issue. And death probate is a problem of assets stuck in a deceased person's name. So joint tenancy and the will both leave us with this problem. Let's say the estate is now worth 2 million and it's all in Pam's name, right? Because she got it under joint tenancy or will. And then she lives for a period of time. Now, on average, a surviving spouse will live about 7 years. And over the remaining life, do you suppose that estate will grow or shrink?
Yes.
Yes, good answer, yes. Yes, very good answer. Statistically, however, it tends to grow. And that's kind of played out in what I've seen in my practice as well. And the reasoning behind that is a surviving spouse tends to be a little more conservative in their spending habits. They're a little bit older, and so they're not necessarily spending on things that they might have spent while their spouse was still around. Now, obviously, a nursing home stay can really make a dent in that, something like that. But generally speaking, estates will creep up over time. So and these are just averages that we have over a 20-year period of time. Inflation, 3%, homes increasing about 5%. And that's kind of strange because if you look at kind of any 20-year segment, we've seen a lot of dramatic swings in real estate. But if you take a 20-year period, you're going to find that that's probably about the case, which has, I think, real estate doubling about every 15 years or something like that on average. Stock market grows about as well over time. We had 9.4 in there for that. So we're going to cheat a little bit. I'm going to have Pam live 10 years and get 7% on everything. Why? Because that's easy math. Do y'all know the rule of 72? You take an interest factor, you divide it into the number 72, and the solution to that is how many years it takes for money to double. So we're just using easy math now. Pam has $4 million, and then she becomes disabled. So who's going to manage the property? Well, the joint tenancy is gone, and the simple will provides no help while someone is living. So we're in living probate, and we're either probably going to wind up with Susan or John. Now, if John happened to be sober on the day of the hearing, maybe he actually gets a shot at it. And then Pam passes away. Now, since all we're left with is the will, that's when we're stuck with probate. So worst case scenario for probate fees, 2 of them, Bob dies, then Pam dies, $120,000. Don't think it would be that high. Let's say, what if we could take out Bob's probate because he owned everything in joint with his wife? And then when she died, the probate was done at 2%, let's say, instead of 4%. In any case, none of this would be fees that we would logically want to pay. Sometimes we're stuck paying them, but there are ways to avoid it. And that's what we're going to talk about. And the taxes are due 9 months after the date of death. So let's just summarize what we talked about so far. If we're trying to avoid living probate, that's guardianship. Joint tenancy, no help while we're alive. Will, no help while we're alive. Death probate on the first death, yes, joint tenancy helps us there, but the will not. And then on the second death, joint tenancy is gone, so it's no longer any help for avoiding probate. And now we've got the will. Basically, in order to free up those assets, we've got to get a court to say that's okay, and that's probate. And then avoiding taxes with both the simple will and joint tenancy, we have everything sliding over to the spouse. And when we do that, that's my Howard Hughes example, and we've lost one of the coupons. Other problems of joint tenancy, and the reason I harp on this a bit is not too much time goes by before someone comes into my office, especially if they haven't been to a program like this, and they'll say, you know, I don't need to worry about anything because I got everything in joint tenancy with my kids. The house? Yeah, the house is in joint tenancy. That could be a problem, you see, because when you add someone to the value of your home, to your home on the deed, you've gifted them half of the value in that home. Today, gift taxes are reportable on a gift tax return at anything over $15,000. So if you gift someone half the value of your home, you're probably making a taxable gift, right? How many people do you suppose actually file the return? So that comes back later on to haunt the children when they want to sell the house. And it also defers some capital gain. I won't get into the technicalities of that, but when you gift someone something, what you paid for it is what they're considered to own it at. So when they sell it, they have to pay the tax as though you had sold it, right? Even though it might be worth a lot more when you gave it to them. So again, if you want some more information on that, come up afterwards. I don't want to get into too much technicalities there, but you could have taxes that you're paying, that you're putting upon the next generation without actually knowing that that's happening. When you put someone on your bank account, for instance, their creditors come with. How many of us in the room want more creditors, right? So just adding a child to an account might bring their creditors along, and you might not want to do that. And there's also no control with a joint tenancy. If you wanted to leave money in an account for a child when they grew up, you wouldn't use a joint account to do this, right? Because at what age could they get to the money?
18.
18, yeah. And at 18, the first thing an 18-year-old does is they run to the bank, they take the money out, and they invest it prudently in a balanced portfolio so that they can retire one day. What is the age? What did you say?
Or they buy a car.
What color is the car, by the way?
Red.
This is not rocket scientists, folks. Rocket science, folks, right? We all know what's going to happen with that 18-year-old. So much that I could put that car up there. Maybe I need to update the car though.
Yeah, it might be a Tesla now.
Every once in a while I get a motorcycle, but that was perfect. You got it right on board. So I'm going to show you an example of a trust. And the first thing I want to tell you is no lawyer can stand in front of you, including me, and tell you you should have a trust, right? Unless they know you and they understand your circumstances. So I'm not telling you you should have a trust today. I'm going to show you a lot of things, and some of them will apply to you. A lot of them won't. But whatever you decide to do, make sure you're sitting with a lawyer that you trust to examine your personal situation. Make sure you're spending enough time to disclose all the things that are important to you, and then get something that's made to fit your circumstances. And when you're doing this, by the way, be on the lookout for what I call boilerplate law firms. So there's a number of firms that kind of got into the trust business in the 90s with a forms book, and they're basically selling paperwork. They're not really estate planning attorneys, so to speak. They've got a form, usually 10 to 12 pages long. And at this stage of my career, I am now rewriting. About 20% of my work is working with people who had a boilerplate plan. And good news is they're still around, so we can fix it. But the problem with boilerplate, or one size fits all, so to speak, is that it doesn't usually really fit anyone very well. So just be on the lookout. If someone quotes you, and by the way, I can't tell you specifically how to figure this out, but when I ask a client who has a boilerplate plan, Not what did they pay for, but when did they get the fee? When did they know how much it was going to cost? They almost always knew before a full consultation was had. It was either like an advertisement, or they called the office, or maybe it was even on their website. This is what we pay. If someone can quote you a fee before they know your circumstances, in my opinion, it kind of stands to reason that you're going to wind up with a boilerplate plan. By the way, another reason that we're getting a lot of this rework is firms that where it was a solo practitioner and the lawyer died or retired. And I just want to make a point of this. We are 3 lawyers strong, separated from top to bottom by 30 years. And we do expect to be here for the next generation and perhaps the one after that. And if those of you online or in the room know of a young attorney that's looking to get into this field, we are hiring. So have them call me. I do train. So with the right kind of individual who might one day be interested in being a partner or an owner in the firm, that's kind of the legacy. We expect to be 3 to 5 lawyers for the reasonably foreseeable future. So just to kind of keep that in mind. I feel sorry a little bit for some of the clients that come to me. It's kind of like when you have to change a doctor or you have to change your CPA. Now they have to come to see me, and it's if they can stay with their existing firm, that's usually better, but sometimes that's not an option. You want to have a trust that fits your circumstances, I guess is the point of this slide. The problem with probate is a problem of ownership. Jointly owned property, probatable on the second death. Individually owned property, probatable perhaps on the first and second death. A better way to own and control property for most people is going to be a trust. You're going to see these green circles, and I'll change the colors every once in a while, and I'll add some arrows. But this is foreshadowing of a trust that we're going to create eventually for Bob and Pam. Once a trust is created, it's given a name, and that's your name, right? Followed by the words living trust. So that's, and by the way, that's got to go on your accounts or maybe on beneficiary designations. It depends what you got and what your plan is, but that's called funding the trust. So funding the trust does not mean buying anything new. It means what I just explained, which is retitling the accounts, getting your individual name on your name, followed by the word trust on the accounts. That's called funding. And that has to happen in order for all of this to work right. So we're going to start up on the top here while both spouses are alive. And we're going to say, hey, if I'm sick, take care of me. These are the babysitting instructions now, right? But not just me, take care of my spouse. I'm going to halt at one moment there and just say, do you think every trust that I've ever written for a married couple says, take care of my spouse? No, because, right, sometimes people come and they've got different ways of handling their finances. Take care of my dependents. Do we all have dependents? No, not necessarily. And some of us have lots of dependents up until, and Gina, thank you for your condolences, up until last month, I had a parent that I was taking care of and children. And now, as those of you know who have grandchildren, I'm sure the stuff's not going to stop there either, but he's not exactly a dependent. But my point is, you want to be able to discuss with the attorney who the dependents are if you've got them and make sure they're taken care of. And the trustees, here we're saying let it be the spouse, but who else do you suppose you might pick as a trustee?
Child.
Child, very common. Anybody else got an idea?
Nephew or niece.
Nephew, niece, brother, sister, corporate trustee, bank, CPA, attorney. By the way, we don't serve as trustees for our clients. It's not a conflict of interest, but it's not really what we do. And so I'd rather that you're with an entity that does that specifically. What about when only one spouse is alive? Take care of my spouse, maybe, yes. Take care of my dependents. Minimize taxes. I'll tell you, anyone who's got taxes always says do that. So that kind of comes with the territory. And then let my trustee or my spouse sign for me. Now, the bottom part of this chart really is, from my perspective, where the rubber meets the road as far as a differentiation between what we call a boilerplate trust and something that was customized. What happens to those assets when you pass away? So I'm just going to explain a few sub-trusts here that we would explain to clients depending on their circumstances. One would be a common trust. So this would be perhaps be for a younger family with kids where the youngest one hasn't maybe finished college yet. Why would we create a common trust? Well, the common trust holds all the assets together until the baby gets out of school. So that the youngest one gets the same benefits as the older one. If when the parent died, you got one out of school and one in school, is it fair to split it in half and then have half go to the older one with an education and the other one's got to pay for their own? If you don't think it is, then we might create that common trust to just hold back. Now, you don't want to hold back the older one though. So the common trust might also say, you know, my older child might be on a graduate school and I want that to be funded as well. But that might be considered an advance. So that when the younger one finishes college, they'll get half. The older one will get half, but minus the graduate school. So, right, so that the baby could go to graduate school if they want to. Children, why would we create a trust for children? Well, one might be that you've got one and they're just too young. Another might be that they're very successful, right? Or they're married. So why would you create a trust for a successful or a married child? Well, a married child might not need the money, right? I'm not saying they won't want it, but they might not need it. So if a child doesn't need it, maybe they've got their own taxable estate and then you pass away and leave them some more money. And then they outlive you by 30 years. Is that estate bigger or smaller? And then they pass away. Now your money's in there, right? And now it's getting taxed when your successful child dies. So we want to look at the next generation and how successful they are, because maybe it would make more sense to have that money set aside in a trust for that successful child's use. But if they don't really need it, they could pay it forward to the grandchildren from you, thereby not having a death tax upon the death of the child, called a dynasty or a legacy trust. How many of you have children that are married or you think might be married in the future? Yeah, so the single largest creditor, unfortunately, that any one of our children are likely to have statistically is a spouse. Okay, so you passed away and you left money to your child, and let's just say that they had a divorce. Where's your money going? We don't really know for sure, but we can guess that some of it's probably going to settle the divorce. Yet if it was set aside in a trust, we could have the right directions on there that would save it for the child. And then maybe again, one day pass it on to grandchildren. You know, you want to provide an education for your grandchildren. A lot of my clients are saying today they're not sure that their kids are going to be able to afford education for their grandchildren. And so we might set up a trust for that purpose. Charity, you want to leave money to the church here. Leave it to the foundation so that it can continue to give. That's the wonderful thing about foundation, is that it keeps giving. You know, it substantiates, you know, and takes care of, you know, there's a lot of facilities here and there's a fair amount of overhead that needs to be taken care of. And we would hope that each generation steps up, but there might be a hiccup somewhere along the way, you know, with either participation of another generation or their financial wherewithal. And they're certainly going to appreciate the fact that people that went before them created the facilities and created the ability to maintain those facilities over time. Others, this could be a brother, sister, a niece or a nephew, a pet. Now I actually have, yeah, I've done programs like this geared specifically towards pet owners and breeders, where they want to make sure that, you know, that their pets are cared for properly. There's a pet statute in the state of Illinois to take care of pets if that's something that's important to you. Now, if you're single, widowed, or divorced, I said we'd cover that. You'll start with one trust. Or you might be married, but have an estate south of 4 million, which you believe is going to stay south of 4 million for the rest of your life. In which case, we might create a joint trust for you as well. It would be simpler. It will be less costly. Right now, we're going to deal with this for a single individual, but understand this could be a married couple as well with a non-taxable estate. What would the trust say? Well, take care of me or us, take care of my needs or my dependents' needs, and let my trustees, my children, sign for me. And again, we've got a whole panoply of possible choices for a trustee. And then after death, where's the money to go? Now, it could go directly in their pocket. And in a boilerplate trust, by the way, that's what happens. When the trust is over, if we're lucky, it's been funded and we avoid probate, but that's it. That's when the trust ends. What I'm talking about here is a trust that would continue, which is most of the clients that we consult with. And again, the common trust, the grandchildren or children's trust, charity or others. These are all the sub-trusts that we saw on the previous slide. So I'm not going to go over those again. If you choose the people we call trustees to sign your name for you, basically, then the trustee, then the court does not get involved in that decision. So I've been using some terms here. The first is a trust maker, also called grantor of the trust. That's you make the trust. And then there's the trustees. These are the babysitters, the ones that you trust to actually run it, which, by the way, would perhaps also be you during your lifetime, and most likely would be. And then beneficiaries, these are the ones that benefit from the trust. Well, that's why we call it a beneficiary. These could be your loved ones, but again, could be you during your lifetime. And if we had to pick one, which one would you rather be? Probably the one on the bottom, right? The one who benefits from the trust. But as I was alluding to, you could be all three, right? So we're going to give Bob and Pam a second chance here. We're going to hit reset on the program, and it won't take as long to get through it again, but we're going to create trust for them. And their goal was to control everything together, right? So we made them co-trustees, and they wanted to be beneficiaries to be able to spend everything while they were alive, occupying all three positions of their trust. And it looks like they have total control, doesn't it? It's because they do. There are absolutely no new taxes. You'll file the same tax returns on your own social. Yay. No new number to remember. How many of us are tired of remembering passwords? Change the plan whenever you want. Absolutely, because these are called revocable trusts that we're talking about today. Bob got sick. What did Pam want to do in our first example? Sell the house, right? But now the house was transferred to the trust, and Pam was a trustee. Can she sell the house without going to court? Yes. Without attorneys, no guardians. She can take care of Bob because it was Bob who was sick in the first place. And Bob would have named Pam as a beneficiary of his trust as well. So she can take care of herself, all without going to court, no accounting to any judge. Does Pam's trust avoid death probate? Well, I didn't say this on the first slide, but the bottom line is, as long as everything is funded right, as everything is retitled properly, we're going to avoid death probate on the first death as well. And for today's example, I'm going to say everything went to the family trust. And who's the primary person in the family while they're alive that Bob wants to benefit? Likely Pam, right? So the family trust is primarily there for Pam. Now, the beauty is, you don't see an arrow going from Bob directly to Pam, because that would then be the Howard Hughes unlimited marital deduction example, where everything goes to a spouse and you lose the credit. So here, Bob's money goes to a family trust, and the coupon or the credit applies. So no matter what's in this family trust, when Pam passes away, there'll be no taxes on it. So assuming that half the estate was in Bob's, half the estate was in Pam's, if this was up to, say, an $8 million estate, $4 million coupon could be used here, and then $4 million could be used on Pam's trust later on. And again, no taxes because we're not, because we're leaving it in a trust and getting the exemption in place. No federal tax and no state of Illinois tax, again, because we're using that family trust to gain use of the coupons. Pam becomes disabled. So now we're back up here. Who's a trustee now? Probably Susan, right? She would have picked Susan, the perfect child. Can she take care of mom without attorneys going to court? Yeah, because she's a trustee. Taking care of mom and other beneficiaries. So what if Pam's trust said, Susan, the child, you didn't know this, but I was sending money to grandma's landlord every month because she was always a little bit short. Could Susan, now the trustee of Pam's trust, if it said, give money to grandma's landlord, do that? Yeah. Would the court have allowed that in our first example? No, because that wouldn't directly benefit Pam, right? She'd have to make a pretty tough case that money should be taken that could be used on Pam later to be used on grandma. But in fact, Susan would have a fiduciary duty if it was in the trust to actually make those payments to grandma or grandma's landlord. Would they avoid death probate? Again, as long as everything's in trust, all these arrows now are pointing down here. You're going to see these yellow circles on the bottom. That's when these get activated. They're all written originally up on the top where both spouses are alive, but they're not activated on here until neither spouse is alive. This is when the children have access. And this is something I want to really stress because I don't know why, maybe I don't stress it enough in programs, But clients will say, well, what about my kid? My kid's gonna have access to my money now while I'm alive? No. They only, because they may not even be beneficiaries by the time you pass away, you might change it. So they don't have any access down here. This is only after neither spouse is living. And again, without attorneys going into court, there are no executors. So there's no executor's fee, no time delay, no public record, or probate in other states. So I'm part of a wealth counsel network, and I've got a loose affiliation with 4,000 lawyers around the country that are part of an educational network that also feed language into software, document creation software that we use. And I can find a lawyer no matter where you own real estate, get a deed written and get it recorded in that county, in that state where it is. And so it won't go to probate in that state either. What about the death taxes? Through the use of the two trust strategy, right? We're going to double the federal credit from 11.7 to 23.4, because we're going to get use of both of those coupons. And we're going to double the Illinois credit from 4 million to 8 million. If these are not issues for you because you're south of $4 million, then we can use a single trust strategy, and that's going to save you money. And it's also going to be more efficient while you're alive. So how did that all happen? Again, we're seeing this slide again. Bob passed away up on the top. You see the arrow going down to the family trust. That would have been the first 4 million. When Pam finally passes away, this is tax-free. Pam has a $4 million credit of her own. That would come down here tax-free. Now, in our example, it went from 2 million to 4 million. So we actually could have stayed with one trust in the example that I used today, because this would be a little bit of overkill. Although we might use it anyways, just because people think their estate might run north of that 4 million. Maybe it's not there now, but they think it could be before they pass away. So they might take that approach anyways. These are some benefits that are put in trust that we create quite often for our clients. We talked about benefiting minors, and we don't want them blowing it on the fast red car, right? So we're going to set it up in trust so they don't get the money till maybe a little later in life. Protecting from divorcing in-laws, we talked about that. Benefiting an elderly person. Sometimes you want to leave money in trust for the elderly person because maybe they're not quite good at managing their finances anymore. I had a set of twin sisters clients, neither of whom had married but lived together for their entire life. By the time they got to me to create their plan, I had to visit them in their home. They had trouble getting to the office. And what immediately struck me was there were unopened boxes kind of all over the house, many of them right near the door. And as I got into it with them, I realized, like, the phone rang 2 or 3 times. And each time it rang, first time I didn't pay much attention. The second time I was like, it was someone telemarketing to them, right? So they were buying things on QVC. They were getting phone calls. They were from a generation that couldn't hang up on someone who was trying to sell them something. So we took some other steps to try to get them protected. But the bottom line is, if we were leaving money to those people, we wouldn't just leave it to them directly. We would want someone else to watch over it, right? Protecting from spenders. If you got a child like John in the family, I have a client who set up a trust for a child like John that starts paying 1/20th of the estate value, that share, on the first year, and then 1/20th every year for the next 20 years. So they've kind of set up a retirement plan for that child because they were sure that they don't even know what IRA stands for, let alone have one. So they set this money up to be marshaled out over time. Protecting estates from creditors. You know, maybe your daughter Susan is an OB-GYN, and one of the highest levels of professional liability insurance available, because if something happens to a baby, someone wants someone to pay for it, and it's usually a doctor, even though it might have had nothing to do with the doctor's experience or what happened. So we set up trust for a child like that, where if they got sued and all of their money were taken in a professional liability lawsuit, the money in the trust would not. So you can set up money to be creditor protected. If you got a child as an attorney or an architect, doctors, lawyers, and architects are 3 areas I know where you cannot, no matter how you shelter yourself in a corporation, there's no way to avoid personal liability. So you got to maybe take some of those things into consideration if you got kids in those professions. We talked about leaving money to successful children and grandchildren, leaving it in the bloodline and so forth. What if the trust survived you for 100 years? Or more importantly, what if your ancestors had created a trust for you 100 years ago? Right? You'd say, Ted, no, that doesn't make any sense. No one left me anything. And I would say that might be a true statement, but maybe not an accurate statement. And let me tell you what I mean by that. I stand before you today, not because anybody died and left a lot of money, but the ancestors that went before me all made sacrifices to try to make it better for the next generation. Isn't that really the American dream, right? We want to do things, build ourselves up and build our families up. And my guess is your story's not that different, right? I'm here because of the sacrifices of those that went before me. So the bottom line is, you were left something. And as a result, maybe you're the generation that now has financial resources to leave behind. Maybe your parents and your grandparents didn't, but now because of the foundation they've laid, you do. And so now we start to think about stewardship, right? And what the Lord has entrusted to us and how we're going to take care of that when we're gone. And that's one of the reasons I love, and I would say probably more than half of my programs these days are done in church settings, is we can talk about stewardship, right? Because that's really what we're talking about. I like to think that what I help people do is the last step in stewardship. What was important while you were alive, and how should we take care of some of those things when you're gone? The ones of you that are in the room, you've got an evaluation form. If you think you'd like to come see me, that's where you'll put the information down. I want to set an expectation, and especially for those of you on the Zoom call, you'll get some information or a link somewhere along the line. We'll give you access. So if you want to contact us or fill out an evaluation, we'll do that. I'm not sure how we've figured that out so far, but I want to set your expectation for what a meeting with me looks like, because I'm not necessarily the best attorney for everyone or the right attorney for everyone. I understand that. So first of all, we require that clients come into a meeting prepared to spend 3 hours. There's no cost for that meeting, but I don't know how to do my job properly without setting aside enough time to do it and to show you options that will fit your circumstances. The only thing you need to bring in is an information checklist. If you prefer to do it manually, no problem, just bring it in. I'm not going to look at it till you get there anyways. So if you want to do it online, we ask you to get it to us 48 hours before the meeting. Because of the way things work through security and eventually wind up with my access, it takes more than a day. Even though you click send, if you're walking into the meeting the next day, I might not have it. So if you're coming off of the Zoom to see me, then make sure that you've done that ahead of time. Again, if you prefer for privacy to just bring that in, that's fine. It takes me about an hour or so to get through that information, and then another hour or so to design options for you. And then at the end of the meeting, my hope is that I'll be able to say, hey, based on what you're telling me you want to do and some things we've discussed, here's your options and here's your pricing. Typically, people have at least 3 options for the way to do things and 3 pricing points related to that. I will fix a fee once I know what you want me to do, but I won't know what that is until we finish with the meeting. So that's kind of the way that goes. Make sure you set aside enough time. Please don't schedule and reschedule. It's very difficult for us to find someone that wants your time on your date in the office that you wanted to go to. So I meet with clients at your convenience at an office that's close to you through the Regis office sharing network. Michael gets me to that space, and we try to get this. We try to just go to one office for the day. It almost never happens. But if you pull out, and someone that day might have wanted to see me in, Orland Park, or up in Lake Forest, it's going to be kind of hard, because we already booked around getting to you and somebody else, in our Lyle Naperville location, which is, I assume, where most of you are probably going to want to come. So again, please don't reschedule if you don't have to. Let's see, we'll estimate your probate, your tax liabilities, design all of your instructions. And then the questions that you don't get to ask today, especially, I don't know how things are going to go. I assume, Scott, at some point we're going to try to do Q&A on the Zoom as well. But if you got other questions, or they're more personal than what you want to ask for in a group setting, or I think they're more personal than answering in a group setting, then you're going to want to bring those into the meeting, and we'll make sure that we get them all answered. So those of you who are on the Zoom, if you don't have this information already, I'll just leave this slide up here so you can reach out to us if you like. And yes, we still do have a fax machine. So although I can't remember the last time we actually got something on it. And they all turn into an email anyway, so it's kind of strange. Oh, I want to talk a little bit about a range of fees. So we don't know what something's going to cost, but I can tell you what people generally pay and what the industry generally is. So in my line of work, the top end of fees these days is probably around $10,000 or $11,000, and that's the top end for us. I haven't charged anybody $10,000, and I can't even remember when. Our average client usually spends between 3 and 6, maybe more like 35 to 65 these days. Fees have gone up a little bit. But again, there's no cost for the meeting, and typically we'll give you prices along a continuum based on what we think is appropriate to meet the goals that you've got. What am I forgetting, Michael? It's been a while since I did a live program. Oh, yes, the Give Back program. Thank you. So the way I actually got to know Gina and got involved with Northern Illinois Food Bank was through our Give Back program. So we give 5% of our fees back to community organizations, charitable community organizations, as directed by our clients, or if not through 6 of which Northern Illinois Food Bank is on our top 6 list of charities that we give to. So, and if you would like to work that out, I can actually just discount a fee to you and you can make the donations directly. We'll talk about that. But bottom line is, when you hire us, we're going to commit to giving 5% of our gross fees back to charitable causes, which kind of at the end of the day, when we're figuring we're giving from gross, winds up being kind of a tithe out of what we're doing. So, and I would think, most people probably here want things to go to the foundation. And our hope is that hopefully, someone on the Zoom or someone here might also be, considering using the foundation here as a part of the trust plan that we create for the legacy of the church going forward here. There's no obligation, there's no exchange of any fees or anything like that for me to do this. Is completely independent. We just voluntarily give out of charities that you pick through the services that we render. So we'll talk about that when you come in. You've heard me a few times. Did I leave anything else out?
No.
Thanks for
The Give Back was the only thing.
Yeah, thank you. So and thank you for reminding me of that. I also have some books that I give away. So if you're interested, come and see me at the end of the meeting. I'm kind of a book guy. I like to give away books. It was interesting. My when I thought about this for the first time, there were books being offered that I thought would be good to give away at Lent at my church. And so I bought, I don't know, 500 or 1,000 of them. I can't remember right now. And then my pastor decided this wasn't the book to give away that year. And I was like, okay, well, maybe next year, maybe not at all. And I don't know about you, but God works on me very slowly. I was kind of like a dunk in the head. It's like, hey, Ted, you've got all these books. Maybe you should start giving them away. And as a lawyer, it just seems to be kind of a appropriate, maybe evangelistic tool, so to speak, for an attorney to spread the word by giving away books. So that's what I do now. So if you'd like a book, come on up and I'll show you what I got afterwards. And if you're on the Zoom call and you want that, we can certainly. Michael, do we want to bring back up me so I can say hello? Can they see me?
They can see you.
Oh, I didn't even know you can see me. Hi. Started talking to everybody here. I forgot about you guys. So sorry. I wasn't sure when that slide came up if that was all you were going to be able to see. So
Can I just say, Ted, I heard Ted's presentation. I think this is the 8th time. And I always learn something, and it just reinforces such important information. And I want to thank you again, because as Ted said, he doesn't charge a fee for this. This is just part of what he does to help educate groups. And we're so grateful that you took your time on a Sunday to come speak to us. Does anybody have any questions?